Hello everyone and welcome to Uncivil Law. For today's video, we are doing a live stream reaction to the recent brief that was filed by Karen Reed's team in the ongoing case of Commonwealth versus Karen Reed. As you will recall, Karen Reed was on trial for running down her boyfriend with her car, and we thought, or at least I thought, that the evidence against her really sucked. Really bad. I thought it was pretty much laughable. I thought it was one of those very rare cases where the court probably should have entered a directed verdict because no reasonable jury, upon consideration of the evidence, could possibly come to the consideration of guilt. There is just nothing there, in my opinion. You can't get there from the amount of evidence that's available. It just doesn't make sense. The state had Trooper Proctor and Trooper Paul, and the less said about them, the better. And then they had Brian Higgins, and the less said about him, the better. And that was kind of the highlights of the state, and it went downhill from there. So the evidence against her was not very good. The jury, in their deliberation, however, hung. Or did they? We'll get to that in a second. But they hung, and the judge declared a mistrial based on manifest necessity. Namely, the jury was unable to come to a verdict. And she's currently scheduled to be retried. Now, there have been stories that have been circulating, including from jurors who apparently have given statements, both to the defense and to the prosecution. Some number of jurors, we're not exactly sure, but 2, 3, 4, some number like that, have said, you know, as a matter of reality, we actually were unanimous as to not guilty on counts 1 and 3. We couldn't make up our mind on count 2. We were leaning towards conviction, which I'm not quite sure how you can get there, to be honest. We were leaning towards conviction on count 2, but we were unable to decide. But count 1 and 3, we did decide. We thought not guilty. But of course, on the jury forms that were turned in, that wasn't indicated. The jury didn't indicate otherwise in writing via note or on the forms that was true. The judge did not inquire specifically about whether or not they had any verdicts with respect to any counts. The judge simply said, okay, well, you're hung, so case over. We all go away. Now, she is trying to argue that, in fact, that what the jury did was, in fact, an acquittal, and therefore it's double jeopardy. I'm of the opinion, despite the fact that I think she's factually innocent, and I think convicting her would be obscene based on the facts that are available. However, I don't think this argument legally works. I'm of the opinion that this argument is not very good because I don't think it's true. The relevant rules in Massachusetts do seem to allow the judge to ask for partial verdicts, and they do seem to allow the judge to enter partial verdicts. So the judge could, under the relevant rules, as I understand them, the judge could have asked, hey, do you have any verdicts? And then having heard the result, the judge might have been able to make the decision to enter them or not. There's a little bit of ambiguity over that, but let's press on. But that didn't happen. But the judge could have done it, but the judge didn't do it. So there's only two possibilities here, legally, okay? There's only two possibilities here. One, the judge had to do it. So my reading of the relevant rule is wrong. There is no discretion. The judge had to do it, okay? That's possible argument number one. The judge had to do it. And so the judge's failure to do that is an error of law. As I said, I don't read the relevant rule that way. It seems discretionary in its text. So I don't read the relevant rule that way. It does not seem like an error of law. Possibility number two, it's an abuse of discretion. Despite the fact that I read their argument and see whether or not they can persuade me, whether or not I'm right or not under the relevant rules. That's what we're going to do. Try to figure out whether or not they can persuade me that I am misreading the law, which, you know, fair enough. Let's see if we can do that. Great. So we turn our attention to page 22 because the first 20 pages or so are just, you know, a recitation of how we got here, which I just told you about. So we don't have to read it again. So I just told you how we got here. So we'll pick it up in, you know, the argument section. Argument number one, the jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. The jury did in fact decide, therefore double jeopardy. Okay. What constitutes an acquittal is not controlled by form. Rather, the court must determine whether an action actually represents a resolution, correct or not, or some of all the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. And there is some case law because in some prior case somewhere, the jury like wrote something on the form rather than checking the box. So in some prior case somewhere that there was a checkbox, not guilty, and they're like, we don't like those checkboxes. We're not part of the checkbox system. We'll just write things on the form instead. And the court was like, well, that counts. You know, the checkbox isn't necessary. We're not sure why the jury thought, necessary to write, superfluous words, but they did, but we'll count it. Cool. All right, I get that. Here are the affidavits by the attorneys. Reflect statements by 5 deliberating jurors, okay, that the jury had reached a final unanimous conclusion that Miss Reed is not guilty on counts 1 and 3. There was nothing tentative about the statements. I don't agree with that as a matter of reality either. To the contrary, they were definitive in describing the result of the jury deliberation. No one thought she hit him on purpose or even knew that she had hit him, one of the affidavits said. So juror C's affidavit said, it was not guilty on the second degree. No one thought she hit him on purpose or even knew that she had hit him. Right about now is where I lose confidence in the jury system. Because if you're like, okay, we don't know whether or not she hit him on purpose. I'm like, okay, so maybe it's not top count murder, but we don't know whether or not she hit him at all. Okay, then it's not homicide. See, the manner of death was the car. At least a substantial contributing factor. But for the car, there is no cause of death. So if you're not sure whether or not she hit him, you can't convict of manslaughter either, because she hit him is a necessary prerequisite to both. But let's press on. Juror D said, in substance, every one of us will agree and acknowledge we found them not guilty on counts 1 and 3 because that's what happened. Okay. So, Juror E explained the jury was unanimous on 1 and 3, and Karen Reed was not guilty of those charges. As noted above, the trial court accepted the foregoing averments as true facts. For the purposes of the exercise, the court did, because the court's like, even if those things are true, it doesn't matter. So like, yes, because the trial court says, as a matter of law, right, even if those things are factually true, it doesn't matter. I'm of a similar opinion. It doesn't count. In rejecting the claim of acquittal, the court relied solely upon the lack of an open and public verdict affirmed in open court. Fair. The reasoning is rooted in formalism. I don't know about that. I don't agree that it's formalism. I don't think that's true. That's been consistently rejected by the U.S. Supreme Court and this court in a string of precedent spanning more than 100 years. Okay. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquittal will not be sufficient. Surely that cannot be the law. I think it is the law. So I disagree with your conclusion. You're not doing great when you appeal to incredulity and you're like, still no? It's not going great for you as an attorney when you're like, if this were true, it would mean all 12 jurors could file an affidavit saying we thought not guilty and she still wouldn't be entitled to this result. And I'm like, yes, that's exactly what it would mean. Because it hadn't been finalized yet. And it's not formalism. There's a process and it matters. So I think it can in fact be the law. Indeed, it must not be the law. I don't think that's true. And indeed, in the context of a highly publicized case, which doesn't matter either way, by the way, the fact that this case has gotten publicity is irrelevant because we're talking about legal principles, so it doesn't matter whether it's got publicity or not. Surely there can't be a different rule whether or not there's television cameras or not, right? I mean, that can't be a different rule because television cameras. That doesn't make much sense. It strains credulity to suggest that if 5 jurors, the unequivocal statements of 5 jurors quoted above did not in fact represent the unanimous view of all 12, the remaining juries allowed the inaccuracy to go uncorrected. Instead, they probably would have notified the Commonwealth or the court of their own recollection. No, not necessarily. I don't think it necessarily strains credulity. The jurors were informed, I'm sure, privately, that they're under no obligation to tell anyone about their deliberations. So I don't think it necessarily strains credulity that some of the jurors may decide to not contact the court, even if they had heard about it, because they're like, I don't want a piece of this bullshit. So I don't think it necessarily strains credulity either. So I'm not going to go about that. Instead, they predictably would have notified the Commonwealth or the court of their own recollection. I don't know if that necessarily follows. Here, to the contrary, the Commonwealth has received the exact same information as the defense. But even if all 12 jurors said, we agree, I don't think it matters. So, yeah. The United States Supreme Court decision in Bluefield is not to the contrary, as it's factually distinguishable. I'm not sure it is factually distinguishable, but you're welcome to try to distinguish from Bluefield. Okay, try to distinguish from Bluefield. There, in the Bluefield case, the foreperson had reported during deliberations the jury was unanimously against the charge of capital murder and first-degree murder, but split on manslaughter. Okay? So in Bluefield, the jury sent back a note saying, hey, we are unanimous, not guilty on some counts, but hung on other counts. What do you want us to do? Okay? The Bluefield court sent the jury back to continue deliberations, figure out some of the other counts. We don't know what to do. Judge said, keep going. Try harder. Try harder. Okay, so the jury tried harder, and apparently they said, okay, now we can't figure any of it out. We were unanimous, but now we're not. We were unanimous, but now we're not. We can't figure out any of it. We don't know what to do. So the Bluefield court said, okay, mistrial across the board. Mistrial across the board. There is no verdict on any count. Mistrial across the board. That was Bluefield. Great. Moving on. The Supreme Court of the United States rejected the defendant's argument the double jeopardy clause prohibited re-prosecution for capital and first-degree murder, because at some prior point, the jury said we're unanimous, and then they said we're not. So were they unanimous or not? The Supreme Court says not. In doing so, the Supreme Court relied heavily on the lack of finality of the jury report. The jury deliberations had not yet concluded and went back to the jury room to deliberate further. The foreperson's report was not final resolution of anything, said the Supreme Court of the United States, and there's no indication at the conclusion of deliberations it was still the case that all 12 jurors believed they were not guilty. Here, by contrast, the juror statements reflect a final and indelible determination that persisted through the end of deliberation and following. No, I don't really think so. And then, of course, there's this sort of conclusion like, okay, as a matter of law, can you just do not guilties across the board? Can you do that? It's like, I don't know. But, I don't think it's that distinguishable, but they're going to try. The contrast with the case of a juvenile versus Commonwealth is even clearer. Okay, we're going to cite some Massachusetts state law. Let's give that a better go. In that case, after conclusion of the trial, the court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of not guilty. There was no indication as to when the entries were made or in what circumstance, much less they reflected a final unanimous conclusion of all the jurors. Neither the Commonwealth nor the trial court has cited any case in which the defendant... And then what happened? And then what happened? You left me hanging. I don't like that very much. Okay, so they found the slips, and then what happened? Okay, that's no good. Neither the Commonwealth nor the trial court has cited any case in which the defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty simply because such a final unanimous agreement was not announced in open court. Okay. The instant cases squarely present the issue, and defense respectfully submits the court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. But even in those cases, there was some sort of writing. There was something, right? Because the court knew from the verdict slips that were left behind or something, but that isn't the situation here. Yeah, at this point, they're going over the precedent. That's exactly right. We're going over the precedent and trying to decide whether or not this case is similar to the precedent or not, right? We're trying to reason by analogy, which is what we do in court. Exactly. So we're going over the precedent and saying, okay, here's what happened in other situations. And is this situation like that situation or not? So yeah, that's exactly what we're doing. Correct. I do not like the way that they left me hanging here, by the way, on this. This is bad writing. This is bad legal writing. They're like, okay, there's a case in which a court officer found verdict slips that said not guilty. And then what happened? You didn't tell me the conclusion. You didn't tell me the end of the story. That's bad legal reading. That's bad legal reasoning, man. I don't like that. Argument number 2. Okay, so argument number 1 is the jury, in fact, came to this conclusion. Yeah, I'm not sure they did. And yeah, there's no writing to this point. There's no nothing to this point. They didn't indicate it. The judge didn't ask. I'm not. Yeah, I don't think I agree. Argument number 2. Alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether evidence supports the jurors' representations. Only if it matters, right? Only if it matters. Well, you'd have to do that in any event. I don't know how you get past that. Like, I don't know how you could even theoretically get past that. You would have to, assuming you're going to do this, you would have to get all 12 jurors under oath and ask them what they actually thought. 5 jurors say we're unanimous, but since when is asking 5 jurors the same as asking all 12? That would be really dumb, right? If we polled the jury and we only asked the first 5 and we're like, well, the rest of them must think the same thing, we're not even going to ask. That'd be really, really dumb. So yes, assuming you're going to do this, which I don't think you can or should, you'd have to ask all 12. 5 do not speak for 12. That's really dumb. The trial court was wrong to artificially limit the right to a post-trial inquiry to develop a substantial claim of a violation and narrow the context of the claims implicating racial bias or the right to receive an impartial trial. No, that's pretty much the only situations in which we invade the province of the jury. We really, really do not want to invade the province of the jury. It is no bueno. And so pretty much the only case law that exists for such a situation is racial bias or impartiality. For example, external things. My personal favorite case to highlight the point was the time during a murder trial in which the jury broke out a Ouija board to summon the deceased, to ask the deceased whether or not the person accused was the person that did the murder. The court thought the Ouija board thing was not the way to go in such case. So, don't do the Ouija board thing, but short of some external influence like that, no. The court has not framed the availability of post-trial inquiry so narrowly. I disagree. But instead stating will permit jury testimony regarding overt factors, by which the jury's validity can be objectively assessed. They mean like external pressure here is what they mean by overt factors. They mean, was the jury threatened? Were they bribed? Were they corrupted? Did someone break out the Ouija board? That's what they mean by overt. But not regarding subjective mental process, such as the reasons for their decisions. Correct. We're only looking for external influences. In a prior case, this court rejected the Commonwealth's suggestion of an inflexible rule excluding all jury testimony offered to impeach verdicts as achieving stability at the expense of doing justice. I'm sure they said that, but Instead, the court ruled where a defendant's claim is predicated upon the presence of overt factors, which again sounds suspiciously like external factors. The law's commitment to a just result warrants receiving evidence, but where a jury would testify solely to matters resting in his own consciousness, for example, what did you think? Did you think not guilty? That would be an example of something that would be resting in your own consciousness now, wouldn't it? What did you think? Not, did someone bribe you? Did someone corrupt you? Did someone threaten your family? Did someone have a Ouija board? Right? Rather, we're trying to explicitly ask, hey, did you think not guilty? Nah, I don't know, ma'am. The dubious value of the testimony is outweighed by the need for stability in the verdict. Yeah. The prior case law recognizes that the line between overt and matters resting in consciousness is not easily drawn, and difficult cases will arrive. Well, that's always true. We're always going to have problems at the border. Welcome to law, but I don't think this is one of them. But it went on to observe, we think it's possible to draw the line in most cases, and this seems more like implicit rather than external. And in any case, the better course is to try to do so rather than refuse to try. The law is clear that in the context of judicial bias, which isn't this either, an affidavit by counsel is sufficient to entitle the defendant to post-verdict inquiry on the issue. Sure, if the argument is that they were sexist, racist pigs, or homophobic, or some other protected characteristic, maybe, but that isn't the situation either. If credibility of the affidavit is issue, the trial judge should conduct a hearing. If we're trying to get to bias, but no one has suggested that bias is the problem. No one has suggested the jury is biased. I've suggested the jury is stupid, but that's not the same thing as being biased. They might be idiot morons, but they're not biased. They're just really dumb. And that's not the same thing, man. No less than the right to an unbiased jury. Mathis says this is all lead-in. Well, it's not leading anywhere positive, Mathis, so it's not leading to great places, Mathis, so I'm not really, I'm not feeling it, man. No less than the right to an unbiased jury is a fundamental tenet of our system of justice. The defendant may not be retried for a crime of which she was previously acquitted. An offense submits a post-verdict inquiry is equally warranted in the present context. No. Other than general noting that present case does not involve allegations of general bias, and that's kind of the end of the discussion, the trial court did nothing to distinguish the legal and justifications from those raised herein. Other than noting the one thing that distinguishes it, they didn't notice any other point of distinguishment? That's a weird sentence. Yes, other than noticing the one simple trick, other than noting the one thing, other than noting the elephant in the room, they didn't point to anything else, Your Honor. Yeah, but the elephant in the room kind of is the end of the game. So, yeah. We have signed oaths. Okay. I'm disagreeing as a matter of law, you understand. So I'm not sure what you're contradicting me on. You say disagree all you want, but we have signed oaths. I didn't say you didn't. I'm disagreeing as a matter of law. You understand that, right? I'm disagreeing as a matter of law, not as a matter of fact. So what are you trying to challenge me on exactly here? Yeah. And like I said, at a different time, if the jury had said unanimous guilty, it would be equally a non-starter. Correct. So if you imagine the counter hypothetical, right? If you imagine the counter hypothetical, all 12 jurors had written affidavits saying, we thought guilty on count 1 and 3. We didn't say it in court, but we thought guilty on counts 1 and 3. Well, I mean, that would have to be equally final, right? Because if the formality of announcing it in open court doesn't count, if we don't need to actually poll them, if that doesn't count, then if all 12 had said, guilty, then she'd be guilty on counts 1 and 3. And that doesn't sound right either. So it's it doesn't work the other way around either. It's it doesn't make sense. The defense respectfully submits that the court should hold that the presence of the unannounced verdict, supported by unambiguous post-trial statements of 5 deliberating jurors, constitutes an overt factor. It is not an overt factor. It is not an overt factor. No. Given the foundational importance of the jury in acquittal of our system, there are circumstances in which the law's commitment to a just result warrants receiving evidence. No. Okay. Yeah. Recently, in United States versus Tarzanov, the First Circuit Court of Appeals remanded the matter for further proceedings in Boston Marathon bombings due to two jurors' postings on social media regarding the bombings and district court's proceedings, which came to light after the juries had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather bias specific to the defendant, which is now an overt factor, because now you have evidence of actual bias. So even assuming that that's basis, then fine, but now you're still talking about overt bias, and that isn't the situation. No one's arguing the jury is biased. That isn't the issue. Why wouldn't the final verdict be a factor unto itself? Because that doesn't make any sense. Like, if you're trying to distinguish overt factors from non-overt factors, you can't look to the verdict itself as its own overt factor, because then the point of distinguishment gets lost, right? If you collapse, you're now collapsing the distinction. Like, okay, why doesn't the final verdict itself count as an overt factor? Well, because if it did, then every single case there is an overt factor, at which point you've lost the distinction. You've collapsed the distinction into nothing. So that's why. It doesn't make sense. Double jeopardy is the underlying argument they're making. As to why she can't be retried, yes, but she can only not be retried in principle because there was, in fact, a not guilty verdict, right? That's the whole point. So double jeopardy is their legal hook for why she can't be tried again, but it's based on a determination. The premise is she can't be tried again because there was, in fact, a result. She was, in fact, found not guilty. That's the premise. Despite the fact that there's no writing, despite the fact that there was nothing said in open court, the jury, in fact, reached the verdict and reached a legally sound verdict of not guilty, which would be equally true in the reverse case. It would be equally true in the reverse case. Double jeopardy is just because there was a verdict already. So it would be equally true in the case of guilt that there would be a verdict already, and she couldn't be tried again because she would have been found guilty. So double jeopardy also applies in that situation. So it's. The comments were also inconsistent with the jury's assurance they did not discuss the case online. Fair. So now you have that, but that's external. And that's not true here. The First Circuit held the district court erred by failing to inquire about these issues. Okay, but you have nothing external like that here. There's nothing external indicating bias, or you don't have anything like that. What about the judge saying not to fill the verdict unless unanimous on all counts? Well, the question is, can the judge do that? That's the issue. Like, can the judge do that as a matter of law? And I think they can. Right? Because, like, can you insist as a judge, can you insist that you have to render a decision as to every verdict, or there's no verdict at all? Can you do that? And I think the answer is yes. I think you can legally. So that would be the point of error, though, right? That would be the point of error. If there was law that says no, you can't do that. If there is a verdict as to some count, you must receive it, right? If you have that, then I would agree with you. But we don't have precedent like that, and none's been decided yet, or none's been cited. So there is no precedent that's been cited that says, hey, if a jury has a verdict, you must ask, you must receive it, you must accept partial verdicts. We've heard nothing like that. We've heard nothing like that. So there's no precedent that supports that proposition. The rule says may. Exactly. The rule says may. The rule appears to be discretionary. So again, it goes back to what I said earlier. It goes back to what I said. There's really only two ways to get past this problem, right? Either one, despite the language of the rule, it's not discretionary, it has to be done, in which case it was legal error. So one possibility is, despite the fact the rule says may, it really means shall, which wouldn't be the first time, by the way, that we've had a situation like that. Well, shall means may, and may means shall, don't you know? Wouldn't be the first time. So one possibility is, despite the language of the rule, it's really mandatory after all, don't you know? And so that was the error. Or the other argument is, despite the fact that it's discretionary, in this particular situation, the judge abused the discretion by exercising the discretion in this situation. So it was an abuse of discretion. Well, I don't think it was an abuse of discretion, and the law doesn't seem to support that it's required, so I don't find any basis to grant the appeal because I can't find it. Is it discretionary based on Massachusetts case law? Both. This is why it's going to the Massachusetts Supreme Court. Because, of course, the Massachusetts Supreme Court is the ultimate authority for what the Massachusetts rule is. I mean, that they're asking the right people. They're asking the right people. If the problem is the Massachusetts rule, asking the Massachusetts Supreme Court what the rule is a really good idea, because the Massachusetts Supreme Court is the ultimate, final, and absolute authority on the question of what the Massachusetts rule is. So they're asking the right people. It's just like, well, I don't read the rule that way. I don't know of any law that speaks to that issue. It doesn't seem correct. So I don't think it's right. But of course, it's an issue of Massachusetts law. So, you know, they're asking the right people. Miss Adventurous Book something, Mouse, I guess, said, Foreman screwed up big time. They're just trying to get the jury back into the courtroom under oath to confirm she was acquitted. Yeah. I mean, the foreperson could have written to the judge and say, we have verdicts on some counts, right? We have verdicts on partial counts. We've reached a decision as to some counts, not others. What do you want us to do? The judge, they could have asked the jury, and the judge might have told them to go to hell. And maybe the judge can tell them to go to hell. Maybe that's a valid thing for the judge to do. But, you know, they didn't even give the court the chance. They didn't even give the court a chance. So it's like, yeah. Given the right to the impartial jury is a constitutional bedrock, where there's a plausible claim the prospective juror lied in a manner that may reveal bias, and that's not the situation, the court need to conduct some inquiry, but that's not the situation, so it doesn't matter. Crucially, for present purposes, the First Circuit or the district court to voir dire the jurors on the issue of bias. In doing so, the court acknowledged that no doubt any juror would have strong incentives to avoid admitting committing perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence in trial, deliberate with other jurors, and reach a verdict they believe is just, would prefer to not have that verdict disturbed, especially as a result of their own actions. We have no doubt the ability of the district court to do what judges do, form considered opinions about sufficiency of jurors' explanations once those explanations are given and explored. On the issue of bias, maybe, but that isn't the situation. In another high-profile case, the South Carolina Supreme Court, HALA, recently agreed to hear claims by Alex Murdaugh that during his murder trial, the clerk of the court improperly influenced the deliberating jurors. Again, that would be the example of an external thing we're looking for. That would be an example of an external thing. The clerk of the court fucking it up is external. So that makes more sense. Jurors came forward after a clerk published a book about the jury trial describing her efforts to obtain a guilty verdict through improper jury tampering. The clerk allegedly told jurors after defense began not to let the defense throw you off, distract you, or mislead you, and warn them not to be fooled. The trial court held an evidentiary hearing on the motion, including testimonies by jurors, in which case Dick Harpootlian screwed his own client, as we've discussed before. As in the prior case, the issue was not bias or racial bias, but in this case, external influence. And this is an external, so it doesn't work. The trial court dismissed Miss Reed's reliance on the case law in a brief footnote, simply stating that the circumstances are readily distinguishable. I tend to agree. But this misses the forest for the trees. I don't think it does. What is certainly true is that all three cases raise different issues. Well, two of them raise external issues, or one of them is bias by the juror. So I guess you might consider that internal. I suppose whether or not bias of the juror is internal or external is an issue of some philosophical discussion, but let's move on. We're discussing either bias of the juror or we're discussing external implications. In other words, we're discussing a corruption of the jury, right? The jury was inherently corrupt because they're biased, or they were fucked with. So that's corruption. So either way, we're discussing corruption of the jury, and no one's arguing that. No one's arguing that there was corruption of the jury here. There is no apparent reason to artificially limit the availability of the inquiry to the singular context of racial bias. Well, I would say external influence or other biases, but no one's arguing bias. So your situation is in opposite, as we say in law. Were you influenced by outsiders? Does that include intimidation from courtroom visitors prior to commencement? Only if the nature of it was external to the process, then sure. If they were threatened, coerced, bribed, sure. If they were just present in the courtroom, no, they have a right to be there just like anyone else. Grow bigger balls. Miss Adventurous says, some jurors want to ask for clarification in the court and the foreman wouldn't. Well, then that's the foreman being dumb, which is unfortunate, but, you know, oh well, that sucks. The defense request does not in any manner infringe on the substance of the deliberation. It kind of does a little bit. To the contrary, the motion dismissed was predicated solely upon the result, namely a unanimous decision that Ms. Reed is not guilty of murder in the second degree. The relevant inquiry could be accomplished by a single yes or no. Did you unanimously acquit jury of the charges? Well, I'm not sure it's that simple, but okay. Of course, the result of deliberations are not secret. I guess, presupposing there's a result, I suppose. They're in fact routinely announced in open court. Yeah, but when they're finalized, though. And the problem is, though, like, you don't know when that is, because the jury can always change its mind until the end. In fact, strictly speaking, they might be able to change their mind once they come back from the jury room, which is one of the reasons we polled the jury in the first place. Because they might have had second thoughts about it from the time they walked from the jury room to the time they got to open court. Until it's final, it's not final, baby. Until it's final, it's not final. And although we've never seen it, every once in a while, every once in a blue moon, a juror says, nope, that's not my verdict. And we go back and we try again. There's a reason we ask. There's a reason we ask. Here the defense has learned post-trial the jury verdict reached a unanimous verdict that was not so announced. It was at least entitled to the opportunity to substantiate the fact in order to ensure Reed is not unconstitutionally forced to stand trial for offenses of which they've already been acquitted. Such an inquiry in no way intrudes on deliberate process of the jury. Such an inquiry instead honors jury service where a trial court described extraordinary rather than disregarding the efforts of 5 jurors to disclose it was not an impasse on all 3 as contrasted to only 1 count. Indeed, it was the trial court, not the defense, that injected issues regarding deliberations into the inquiry. It's simply not true that given the content of the final note to the jury, any inquiry would necessarily require the court to understand why the notes communicated deadlock on the charges, when a post-trial, certain deliberating jurors are purportedly stating the jury was in fact unanimous. As explained infra, in light of the court's instructions repeatedly characterizing the lesser included as discrete charges, the jury's note is readily susceptible to interpretation consistent with post-trial evidence supporting defense motion. In any event, if jurors state that they acquitted Ms. Reed, no further inquiry regarding the content of the note could possibly remove the implications of the acquittal. Okay. And re-prosecution is independently barred because there's no manifest necessity to declare mistrial when it was not deadlocked. Well, presupposing it's not, Are jurors, as a juror, are they allowed to believe another person's responsible for a crime if it's not presented by the other side? A jury is allowed to believe any conclusion that is reasonably drawable from the evidence or reasonable inferences thereto. So how does that answer your question? So they can believe any conclusion that is based on the evidence or any reasonable conclusion thereto. Of course, in the context of a not guilty, of course, the jury only has two verdicts, guilty or not guilty. So the evidence proves it or it doesn't. The jury is under absolutely no obligation of any kind to believe that someone else did it, someone else is responsible. In fact, they can believe that Karen Read did it and still be not guilty, because those are not the same thing, right? The jury is under no particular obligation to believe that Karen Read did it or not. They only have to answer the question, is there proof beyond a reasonable doubt? That's the only question they have to answer. And so the jury can think that she did it. They can think that she didn't do it. And they can still come to either verdict. Well, if they didn't think she did it and reached guilty, that would be, obviously perversion. But, they could think either thing and think not guilty at least. So, yeah. Suppose they want to ask, did you find her not guilty? Did you not deliver the verdict because of threats? That's allowed, but they can't ask if no threats. There would have to be evidence of threats. You can't go fishing. You can't go fishing. So if the argument is the jury was threatened, you need evidence to present that claim to court. You can't go fishing. So what is your basis for believing the jury was threatened? None of the jurors seem to say that, so you have no basis to ask the question. Absent defendant's consent, state and federal double jeopardy protections bar as a general rule retrial of a defendant whose initial trial ends without conviction. The rule is rooted in the importance of defendants to be able to once and for all conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Where a mistrial is entered without defendant's request or consent, retrial is impermissible unless manifest necessity. Important, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Yeah, but the jury was hung though, so that's kind of the, yeah. And this burden remains solely upon the Commonwealth regardless of whether the defense objects. Fair. Before a court declares a mistrial, the counsel must be given a full opportunity to be heard, and the trial judge must give careful consideration to alternatives. But I think that already happened. They're trying to bitch. They're trying to bitch that the last time the jury came back, they didn't ask for any argument. But after they gave the deadlock instruction, there was nowhere left to go. Everyone knows the deadlock instruction is the end of the game. Any further step after that is problematic at best. So they're going to try to bitch that we weren't given a chance. Yeah, but you had been given a chance 2 times already to argue about the mistrial thing. On 2 separate occasions, you were given a chance to argue and nothing had changed. It's the same argument. It's like, we already know what you're going to say. You had a chance. And we already gave the deadlock instruction. Game over, man. Game over. Here, the defense respectfully submits lack of opportunity to be heard as dispositive. No. In my humble opinion, no. Upon reaching the final note, the court declared a mistrial and excused the jury without consulting counsel. There was nothing left to do. There was nothing left to do. What are you going to do? What are you going to do? Argue they should keep deliberating? You can't. No. It's over. What possible argument could you make? You see, that's the other thing too. It's like, we weren't given a chance. Okay, like hypothetically, what would you have argued? They gave the deadlock instruction, man. There's nothing left to do. The action was sudden, brief, and unexpected. Also, that's bullshit. Once that deadlock instruction gave out, anyone who's a lawyer knows what's happening. It's sudden and unexpected and no one could foresee it. Like literally every lawyer can foresee it. There's only there's only two things that are going to happen at this point. The jury's going to come back with a verdict, or they're not. Either way, everyone's going home, except maybe the defendant, who may or may not be going home, depending on the jury. But everyone else is going home, right? There's nothing else to be done. So it was sudden and unexpected. No, it's not. And the language of the previous note was pretty strong too. Oh, we had no idea the jury was so torn from their previous note. No one could possibly have figured it out. And then we have some cases in which, there were some situations in which we didn't give them a chance, but I don't think that applies in this situation. Defense was given no opportunity to object to declaration or advise the court of the imperatives of the criminal rules, request that the jury be polled, or discuss the issue with Mr. Reed. You could have asked anyway, by the way. And it's not like it's a surprise because, again, it wasn't like the first time they heard it. It wasn't the first note that came back and be like, oh, we're hung. And the judge is like, okay, bang, 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 mistrial. It's not. No one could have seen it coming. The defense respectfully submits, given the importance of double jeopardy protections and profound implications for retrial, an opportunity to heard must be, in order to be meaningful, occur after a reasonable opportunity to confer. I think that kind of happened. Counsel for Ms. Reed had no such opportunity here. I don't think that's true. Whether or not the trial court was obligated to obtain personal consent, its failure to ensure that counsel had an opportunity to consult with Ms. Reed on the issue undermines the existence of manifest necessity. Yeah, but you had given the deadlock instruction, though. And you had time to consult. Again, there's only two possibilities. Once that deadlock instruction is given, there's only two possibilities. The jury has a verdict or they don't. Either way, we're all going home, except maybe the defendant. So I don't buy this, man. The record is independent, lacking on the second prong, as it reflects no careful consideration of alternatives. There is no alternative. What would the alternative be? The only possible alternative is keep deliberating, but we already gave the deadlock instruction. So, no. Here, one alternative was to ask the jury on which charges it was deadlocked. Okay. This option, and right away, we know we're in trouble. Right away, we know we're in trouble. This option, it's something that they could have done. This option is apparent from the face of the rule, which states that the judge may declare mistrial as to whether any charges the jury cannot agree upon, provided, however, the judge may first require the jury to return verdicts on those charges of which they can agree and direct the verdicts be received and recorded. And then, as I sort of was having an argument with someone else in a prior thread, whether or not the judge has to enter the verdicts is unclear from the grammar, because it's unclear whether or not may persists. So is that mandatory or not once you do it? I don't know, because the rule is ambiguously worded. So there's ambiguity left to be decided by another day. And does the word may persist? Because it says the judge may first require them to return verdicts. Okay. And may/shall direct the verdict shall be received and recorded. Well, which is it at that point? Does the word may persist the entire sentence or not? Fun with grammar. In fact, the reporter's notes expressly indicate the receptions of the partial verdicts is required, but that's the notes, not the rule. The notes might help you understand any ambiguity in the rule, but it's definitely not the rule. The note is not the rule. So the note says this rule provides the court may declare a mistrial in cases where the jury is unable. However, it first must receive and record the verdicts. Well, first of all, the note to the rule is not the rule. And second of all, to the extent that you think it says must, the rule says may. And the rule is superior to the note. Otherwise, what's the point of the rule? Right? The note is commentary on the rule. But if you interpret it that way, the rule's in conflict. The note is in conflict with the rule. So the rule wins over the note. Had the court inquired as to the existence of partial verdicts and the jury articulated its consistent verdicts, the double jeopardy implications would be clear and decisive. Well, it'd certainly be a lot clearer, because at that point, had the judge said, no, I'm not going to enter them anyway, right? Had the judge said, okay, do you have partial verdicts? And they said, yeah, we're not guilty on counts 1 and 3. And the judge said, you know what, that's interesting and all, but I'm going to declare a mistrial as to counts 1, 2, and 3. Well, obviously we're in a different argument now, aren't we? We're in a different argument now. And depending on how you read the rule, right, if the word may persists throughout, right, because it doesn't indicate shall, it just says may. So if you understand the word may to persist throughout, then maybe that judge can do that, but it's a different argument now. It's a different argument on the finer points of the grammar of the sentence. Break out your sentencing diagrams, everybody. But it's a different argument. But since the judge wasn't required to ask in the first place, we're not there. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. True. Not true here, but yes. Mathis Greaves for 10 euro says, as a mathematician, it can just seem absurd that we can inquire into a jury's verdict to fairly and partially render the verdict, but not about the render part legally defined in open court. Welcome to law, baby. Welcome to law. Rules and exceptions built on rules and all the rest of it, man. Got rules and rules built on rules and exceptions built on rules. The whole thing has been cobbled together. Think less like a mathematician, think more like an engineer, okay? Law is less mathematics and more engineering. It is held together with duct tape and string, okay? And most of the time, it works fine. But every once in a while, when you look at it closely, you find the duct tape and string, and you're like, this is a bit of an absurdity. And you're like, look, the duct tape and string has been in place for 1,000 years, okay? It's duct tape and string, maybe. You just have to roll with it, okay? So think less like a mathematician, think more like an engineer. It has been cobbled together, and it works most of the time, so leave it alone. All hail the machine. Mom. In denying the motion to dismiss, the trial court erred by relying preliminarily on the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law placing a burden of establishing manifest necessity squarely on the prosecution. The defendant in a prior case was charged with operating a vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after a trial began, one of the jurors recognized a witness and informed the trial judge he might not be able to be impartial. The judge excused the juror. Left with 5 jurors, the judge and attorney briefly discussed how to proceed. Defense counsel expressed frustration over the impanelment of only 6 jurors and then stated, I don't think we can go forward with 5 jurors, can we? The judge responded, not in a criminal case. Okay, I'm going to declare a mistrial. Seems like it. After a retrial was scheduled, the defense moved to dismiss on double jeopardy grounds. The trial judge allowing the motion find that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with consent. Okay, well, you fucked that one up, didn't you, Judge? The judge therefore found he had failed to give careful consideration to alternative of proceeding with less than a full jury, and accordingly there's no manifest necessity. Incidentally, by the way, for what it's worth, not that you really care, but the federal rules of criminal procedure allow for 11-member juries if you lose a juror. So they do allow for it. And then, of course, the state of Florida, in its infinite wisdom, does 6-member jurors for everything except capital cases, which is pretty freaking weird. But that's what they do in Florida for some reason. I don't know. On appeal, this jury began from the premise that due to the importance of double jeopardy, the Commonwealth bears the heavy burden of proving mistrial. The court then agreed with the trial judge the defendant could waive his right to a jury of at least 6. It rejected the Commonwealth's argument the defendant in the case had not provided such a waiver, observing the question is not whether the defendant executed a valid waiver, but whether it was manifest necessity for declaring the trial. Such necessity would have presented itself if defendant had declined to execute the waiver, but the record is clear that neither judge nor counsel was aware of even considering the option. In these circumstances, the Commonwealth was unable to satisfy its burden, so the rule allowed for 5-people juries, so it wasn't manifest necessity. But here, the rules do not allow for non-unanimous. Yeah, the rules do not allow for this, so I don't know. Yeah. Did the defense see the amended jury slips? Of course they did. Of course they did see the amended jury slips. And the jury had the amended jury slips. Of course they did. Defense respectfully submits that the same question result is required here. It's the prosecution's burden to alone to establish, because, for example, if they hadn't, that would be a different argument. So the reason I can say with complete confidence, of course the jury had the amended jury forms, and of course the defense had it, was if they didn't, they'd be screaming about that. And they're not screaming about it, so obviously they had it, right? So, yeah. So it's pretty safe to draw that conclusion. Here, there's no doubt the court was permitted to accept a partial verdict. No one disputes that. But the record simply reflects no consideration of the option. Well, it seems like the judge was against it from the start. My understanding is the judge had said no partial verdicts like multiple times. So the judge apparently had said at an earlier stage, yeah, I'm not going to do this. I'm just not gonna. The rule says I can, but I'm not gonna. And unless you can show abuse of discretion, I'm not gonna is a completely valid answer. Right? Just as a matter of taste, I'm not going to do it. So unless you can show in some case it's abuse of discretion, like, this time you really should have, Your Honor. I understand that normally you do this, but not this time. You really should have. No, I'm absolute in my rule. Well, no, justice must be done and all the rest of it. But I'm pretty sure the judge said, no, I'm not going to do it. And I don't think you had to. And that this isn't a case that, cries out for some, desperate, this time you really should have solution, so no. A judge has no affirmative duty to see that justice is done. Ooh, that's careful. You got to be careful with that, Mr. Sniffles. You got to be really, really careful with something like that, saying a judge has no duty to see that justice is done. Because what justice is a whole nother set of problems. A judge's duty primarily is to ensure the rules are followed. We live in a world of rules, and to ensure the rules are followed. They are the umpire at the game to make sure that the rules are followed. That is the judge's job. The judge's job is not to ensure justice in some cosmic sense. It is to ensure that the rules are followed and followed properly. It's product by process, to quote my field of patent law. It's product by process. We don't know how to get a good result, but we do know how to get there. Yeah, we can't tell you what a good result looks like, but we can tell you how to get there. If you follow the directions, you'll get to the promised land. And that's the judge, is following the directions, and we get to the promised land. So you got to be really careful with a statement like that. Let's see where we are. The trial court's ruling that Ms. Reed's counsel implicitly consented to the mistrial was based primarily on the request for the deadlock instruction. Of course, whether a jury has engaged in due and thorough deliberation to support the instruction, and whether there is manifest necessity to declare a mistrial, are distinct legal questions. Well, only in so much as you can hypothetically have one without the other, yes. But yeah, not as distinct as you suggest. Unsurprisingly, neither the Commonwealth nor the trial court cited any case finding defense consent to a mistrial can be based on a prior request. Yeah, maybe not, but it's kind of implicit. Thank you, Christy, for the 10 gift memberships. It's appreciated. Here, defense counsel request did not reflect any implicit concession that the jury was deadlocked on all counts. It's a deadlock instruction, so it kind of is. That is a strange argument, ma'am. The defense's counsel's request cannot be understood as an implicit concession they're deadlock. It's literally a deadlock instruction. I'm pretty sure it can be. If it's true that if the jury reports an impasse, they shall not be sent out again without their own consent. The fact, however, does nothing to undermine the alternative, simply inquiring whether the jury has reached a partial verdict. Doing so would not send them out again. Again, they could have. The question is whether or not they had to. The trial court erred in requesting the charge without acceptance or acquiescence. You're trying to turn the optional rule into mandatory rule. And so I don't think you're going to be able to do it, but I think, I don't know, man. Although it would be easier for the court to simply say, this case should be dismissed because there's no evidence. That would be easier. This case should be dismissed because the evidence against them is Garbo land. That'd be easier. But that's not your petition for relief, although it really should be, in my opinion, but okay. Or at least it should be included. Maybe you get there. Maybe it's included. It should be there. I know it's really, really tough. I know it's really, really difficult. I know it's like basically borderline impossible. But this time I'd give it a shot. Whether she knew that she hit him? Okay. I misread it. Whether she knew she hit him? Did I? All right, I'm on page 42. Hold on, where was it? Can it be manslaughter without knowing you hit him? Oh, maybe. I'd have to reread the manslaughter rules. What does it say? Or even knew that she had hit him. Well, knew that she hit him is in brackets, which means it's a paraphrase. So I'd have to go back to the original because I don't think that that's an accurate quote. So now we have to go back and find the actual quote because it's in brackets and I feel like it might be being misquoted. Has the defense deceived Uncivil? Because I feel like they might have. I feel like I'm about 5 seconds from calling out the defense for basically lying to me. Let's see if we can find out. Let's see if we can find this previous thing. Hold on. Yeah, not only is it a paraphrase, it's a quote of a text, a message to someone who talked to the jury, not the actual juror. Yeah, so it's like, it's hearsay. But what is the actual quote? I have to... No one thought she hit him on purpose or even thought she hit him on purpose is the actual quote. The actual quote is, no one thought she hit him on purpose or even thought she hit him on purpose. Yeah, I'm back to my prior comment. I called you out, defense. I called you out. Defense lied to me. I read the original. I'm like, I don't think that's right. The juror, Bentley RM in chat says, the juror wrote the original text incorrectly and then clarified it in an affidavit. Okay. I don't even know what to do with that. That they wrote it incorrectly in the text and then clarified it in an affidavit. I'm not sure necessarily that's a really strong point of support for you. It's like we can't even figure out which of the statements to go with now, but okay, sure. So apparently they corrected the statement in a later affidavit. All right, noted. Okay, fine. Oh, Lord, I'm not sure what to do with that. Let's press on. Bad game of telephone, my friend. It's a bad game of telephone. Moreover, the trial court's characterization of the jury's final note as making it clear that jurors would not consent to continuing their deliberation is belied by the case law. Bullshit. That jury was done. If that note is not, we don't want to play anymore, I don't know what note is. Do you really think that that is bullshit? Bullshit. The trial court's characterization of the note as making it clear that the jury would not consent is belied by the court's. No, did you read the note? I'm not sure it could have been any clearer. The jury doesn't want to play anymore. I'm not sure what words they could have used to make it any clearer. There's not a lot of ambiguity in that note, man. They're about 5 seconds away from including case citations in the note. I'm surprised it didn't include citations in the note. For the jury, like, we really don't want to. That note is not ambiguous, man. Jam. In Commonwealth versus Jenkins, the jury reported after a different charge, they felt strongly there was no hope of progress and requested further instructions. The court responded by telling the jury, I cannot force you to continue unless you agree to continue, but then by asking them to retry and decide whether further deliberations will be fruitful. The jury promptly reached a verdict. This jury was done, man. They were toast. They had 2 or 3 times written a, we beseech you, dear sirs, we cannot possibly agree. This note was the most well-written we cannot agree note in the history of jury notes. If this note is ambiguous, there's no hope for us all. If this note is ambiguous, we're all doomed, man. I'm surprised it wasn't done on parchment with I bequeath you and all kinds of shit, you know? Damn. Thus, another alternative mistrial, in this case would have been informed the jury could not be required to consider and ask them to retry. Really, this jury? I guess technically, sure, the judge could have done that, but I don't know, man. I think like if the judge had done that and they had found guilty, I think the defense would be bitching. I'm just guessing, you know, if the judge had said, you know, hey, you know, I can't force you to, but would you like to give it another go? And they're like, you know, okay, fine. And then you said, you know what, we think guilty. I'm pretty sure the defense would be bitching. So I'm not, you know, I'm not as abusive discretion goes, you know. Here, neither Miss Reed nor her counsel was provided with an opportunity to object. All the cases cited by a trial court on the issue are readily distinguishable. For example, in a prior case, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held defense had an opportunity to object, given the mistrial was declared after voir dire and colloquy after the jury was cleared from the room. Here, by contrast, the defense did not learn of the contents of the jury note or its court's intention to declare a mistrial until the judge called the jury and stated the declaration of mistrial. Counsel was never shown a note from the jury. The judges indisputably never informed counsel of the intention to declare a mistrial, much less solicit views. I feel like this is so petty. For the court to hang its hat on this, it's like, I guess if the Supreme Court of Massachusetts is really looking for an excuse to make this case go away, then I guess they can say that the trial court erred by not asking the defense for its thoughts after the receipt of that last jury note. Now, to me, that seems like it would be borderline futile in this situation, because, like, what are you going to say? What are you going to say, right? So to me, it seems borderline futile. But I suppose if the Supreme Court of Massachusetts really is looking for an excuse, they've got one, I guess. I mean, to me, it seems like it was done as a matter of practical reality. We had heard from you already. It's the same argument. We've done the thing, right? And so, sure, we didn't ask you that last time for your thoughts, I guess. And I if this is where the Supreme Court of Massachusetts wants to go down, if they want to distinguish on that grounds, it's only because they're looking for an excuse to make this go away. So I guess that the Supreme Court of the state feels like this is an embarrassment, which they very may well do. If they're looking for a reason to make this go away, then I guess, but yeah, I feel like you're stretching really hard to find that one. It wouldn't be the first time a court has stretched really hard, though, to find a result that they want, though. So if they're looking for an excuse, I guess, man, damn. Compare United States versus McIntosh, in a case where defense counsel at one point implored the district court to declare a mistrial because the jury was deadlocked, saying it would be Kafkaesque wrong, nice, to allow parties to freely advocate on appeal positions dramatically opposed to the positions taken by the parties in trial court. Yeah. As the appeals court has explained in analogous factual content, the suggestion that counsel could or should have immediately objected to the sua sponte declaration of mistrial underestimates or ignores the difficulty in reaching the decision in which the defendant has an evident personal stake, where the defense would be advantaged, or the opposite by a second trial. But, like, it wasn't some massive surprise, though. It wasn't the first note out of the gate and the judge said, you know what, I'm giving up. Mistrial all around. You get a mistrial, right? It's not, there's definitely a situation, but I'm not sure it's this one, ma'am. Therefore, to equate silent with consent when the occasion comes abruptly and unexpectedly seems quite unwise. If it were abrupt and unexpected, maybe, but to call this abrupt and unexpected is, I don't know what game you're playing, man. There's not, how do you think this was going to go? To call this abrupt and unexpected, I don't know what you're doing, man. To call this abrupt and unexpected, man. This isn't it, man. The trial court suggestion the defense counsel had an opportunity to object after it occurred and jury had been discharged is mistaken. The judge expressly told the jurors, your service is complete. I'm declaring a mistrial. Yeah, but you could have objected while the jury was being brought in, or said, I mean, just in principle, you could have said, Your Honor, could we talk about it some more? Or could we approach, or can we have a moment to talk about it amongst ourselves? Or can we have 5? You could have said a lot of things, man. Just saying. Given counsel's lack of opportunity to be heard and the court's lack of consideration, defense respectfully submits the prosecution has not satisfied its burden. This is the only thing I can see the Court of Appeals latching onto. Because they are desperate to make this case go away, which, given the embarrassment of this case, given the embarrassment that is Proctor and Paul and everything else, given the shit show of this case, given the fact that the feds are kind of breathing down everyone's throat and everything else, if I were the Supreme Court of Massachusetts and I were looking for a reason, if I were looking for a fig leaf to make this all go away, I guess, right? If you the problem was, they didn't ask. You should have asked, even if it's basically borderline conclusory, You know, even if it's borderline conclusory and we all know exactly what's going down, you should have asked anyway. I guess, man, damn. While the trial court observes a jury deadlock may be grounds for mistrial, it cites no precedent for the counterintuitive proposition that a deadlock with respect to some but not all counts constitutes manifest necessity. Although, to my mind, it would be easier, although they haven't been asked. And so it would be really, really weird, although it wouldn't be unheard of. And also, it's the Supreme Court of the state, so they can kind of do whatever the hell they want at the end of the day. But to my mind, it would be even easier and more intellectually honest to say this case should be dismissed because there is insufficient evidence to convict. That would be the easier grounds. It would be more intellectually honest. They haven't been asked to do that, but it wouldn't be the first time that a court, including the Supreme Court of the United States for that matter, it wouldn't be the first time that a court has ruled on completely alternative grounds to those suggested by any of the parties, because there's a different reason. So if they're looking for a reason, I think the easier, more intellectually honest reason is no reasonable juror could possibly believe this. This case is a shit show nightmare of stupid, and no person could possibly believe this on this factual pattern. So it should be dismissed. It should have been dismissed at the end of the state's case. It should have been directed, not verdict. It should have been directed, not guilty. Would be the most intellectually interesting way to deal with this, which would both be more intellectually honest, less legally dubious, and also a bigger fuck you to the trial judge, incidentally. So if I were the Supreme Court of Massachusetts, that'd be what I'd be looking to do. No one asked me to do it, but then again, I'm the Supreme Court of Massachusetts, so I don't need to be asked, and I can just do things because I'm the Supreme Court of Massachusetts. So that would be my preferred way to get rid of it. In fact, I might even go so far as to ask for briefing on this alternative issue. It's like, well, which again, the Supreme Court sometimes in the United States has been known to do, right? So it's unusual. Usually the Supreme Court, when they accept the case, they'll accept the question presented. But every once in a while, they'll change it. And every once in a while, the Supreme Court will just write its own question, which is a pretty big clue, right? The Supreme Court's like, yes, we're going to take it, but we're going to provide our own question. So they could do that too, and that would be a pretty big clue about what they're thinking. The lack of precedential support is no accident. Such a rule run counter to the important issues underlying the constitutional safeguards. Contrary to the trial court's suggestion, there's nothing in the jury's notes that directly contradicted the post-trial affidavit by counsel. As an initial matter, there's facial tension between the observation of the court and a stated acceptance of the affidavit as true for the purpose of the motion to dismiss. No, there's not. There's no tension. There is no tension because the trial court doesn't think it's a matter of law. It works. I tend to agree with them. So there's no tension. I'm not tense. Yeah, the snowblowers and the solo cups. Yeah, I don't know if I could necessarily write that, but I'm tempted to, as the Supreme Court of Massachusetts. Like snowblowers and solo cups? Really? Seriously? Question mark? Maybe with a little sketch of what a solo cup looks like in the opinion. It's unusual for court opinions to include art, but you know. Indeed, the court repeatedly referred to those lesser included offenses distinct charges, which, both its initial and supplemental instructions, although as to that, you didn't object to that part. So that part's on you, defense lawyer. If you think that that's a problem, you should probably have objected to that. You didn't. You objected to something else. They fixed it. You can't now bitch. In this context, the juror's note was facially susceptible to two alternative interpretations. The jury had reached an impasse on all charges, or the deadlock applied to only some of the charges. The information received by the jurors post-trial proves the latter interpretation was correct. Well, I don't know about that, but okay. The juror's failure to expressly mention agreement on counts 1 and 3 is understandable. In light of the court's instruction, it should continue deliberating until reaching a final verdict on all charges. Yeah. You could have mentioned it anyway, though. I'm just saying. The foreperson apparently didn't want to, but, that's their prerogative. The court's holding in Commonwealth versus Roth that the court should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that inquiry concerning partial verdicts on lesser included that have not been separately charged carries a risk of coercion. You can't ask for partial verdicts on lesser included. No similar danger is present here, whereas the jury is asked to return 3 separate verdicts on 3 separate counts. Sure, they could have returned verdicts on any of the counts independently. That would have been fine. At least legally should have been fine. In circumstance where the jury reports a deadlock without specifying the counts on which it's reached an impasse, it's straightforward and defense contends constitutionally required based on what? Wishes and dreams. You have no authority for this proposition that's constitutionally required. The rule doesn't constitutionally require it. I don't know of any case. You haven't cited any. You just wishes and dreams. If the Commonwealth of Massachusetts wishes it to make it part of its constitution, it certainly can. It's its constitution after all. But I don't know that they want to do that because that would potentially upset a whole lot of verdicts that are potentially still live. So that seems like a really dumb solution. The nice thing about the there is no evidence in this case go away is that it has no precedential effect. All right. Any rule, any legal rule like, oh, they should have asked, or, oh, it's constitutionally required could impact other cases. Right. So one of the dangers for the Massachusetts Supreme Court is, okay, if it wants to go down this road, there are other cases that could be impacted by this decision because a legal rule would impact any decision that's still alive. In other words, in which its appeals are still ongoing, which could potentially be dozens or hundreds of cases. I don't know, but it potentially lots of cases. The nice thing about there is no evidence in this case go away is it has no precedential effect because the failure of sufficient evidence is just the rule already. And all you're saying is, well, we found it. We found it. So you're not creating a new rule. You're simply saying the rule should apply here. So you're not creating a new rule or a change in a rule. You're simply saying the rule applies here as a matter of fact rather than a matter of law. But, contrary to the trial court's suggestion, any inquiry regarding the jury had reached a partial verdict on any of the charges would not be forbidden. There's simply nothing coercive about asking a jury reporting its deadlock to whether it has counts onto any of the counts. I agree. That would have been fine. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth. Okay. Would inevitably undermine defendants' important and constitutionally protected interest in being once and for all to conclude their confrontation with society through the verdict of a tribunal they might believe favorably disposed to their fate. And the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it's completed. The Commonwealth's proposed rule would undoubtedly hinder law enforcement interests by precluding courts from asking whether they may have reached a guilty verdict on some, not all. The Commonwealth is not suggesting they can't. I don't think the Commonwealth is suggesting they can't. They're just arguing they didn't. And those are not the same thing. It's uncontroverted that, according to a jury of her peers following a trial, Miss Reed was unanimously found guilty. That undisputed fact must not be lost in the analysis. I like my alternative solution better. There is no evidence go away. There is no evidence goes away is a much better solution. This case is a farce. Go away is a much better solution. It bears repeating that the heart of this policy is concerning that permitting the sovereign freely to subject the citizen to a second trial would arm the government with opponent evidence of opposition. Assuming arguendo, the court finds counsel consented to mistrial, defendant's personal consent would be required. That's probably true. The defense repeatedly submits that whether it consented and risked the prospect of retrial should be a decision for the client. That might be well true. Some basic trial choices, including the decision whether to plead guilty, waive a jury, testify, or take appeal, are so important that they must seek client consent. Double jeopardy, where after consultation with client, defendant elected to accept an offer of mistrial. The Supreme Court has recently shifted the balance on power between counsel and client regarding fundamental decision-making in criminal cases. Assuming arguendo, the court finds counsel consented, defendant contends it should address whether the decision to forego a jury verdict is among the fundamental questions. Interesting. I'm not sure how necessarily it pops into this case, but fine. For the foregoing reasons, we would like this appeal. And they didn't once say this case should go away because there's no evidence, which is kind of disappointing. Which I would certainly have made as a backup argument. You know, I know how hard that is. We all know, all the lawyers know how hard that is. We all know how hard it is to get the Court of Appeals to say, this case is so batshit nuts, no reasonable juror could possibly believe this bullshit. We all know how hard that is. That being the case, however, I think this is a case in which I would feel comfortable making that argument. I'd probably expect to get my teeth kicked in because I know how hard it is, but I'd make the argument because I think I can in this situation. I think I can try. So I'm a bit disappointed they didn't do that. And the Supreme Court of Massachusetts could either say, hey, do you want to make this argument? So they could either order additional briefing, pose their own question, or just decide an alternative grounds for the hell of it. You know, they can do all those things because they're the Supreme Court of Massachusetts and they can do whatever the hell they want. But yeah. So the best argument from this brief is you really should have asked us after the conclusion of that. You really should have asked us after the conclusion of that thing. After the receipt of that last note, you really should have asked us, despite the fact that it's basically pro forma. But we won't say that part out loud. Despite the fact that it's basically pro forma, you really should have asked us anyway, because maybe we would have had super interesting creative arguments and you didn't give us a chance. Okay. So that's the best argument on the brief, is that they should have done it, despite the fact it seems pro forma, but we'll all pretend it's not, so that we can, rule for your favor and make this case go away. Right? That would be the best thing from this brief. I think better, though, is the argument, no reasonable jury could believe this bullshit. It should have been dismissed after the presentation of the state's case, because there is no evidence beyond a reasonable doubt. Yeah, that's what I think. So, yeah. But we'll see, of course, what the Supreme Court of Massachusetts wants to do in its infinite wisdom. So we'll see how they're feeling. Karen's Reed best hope. Karen Reed's best hope is the realpolitik argument. That's Karen Reed's best hope, is the realpolitik argument. Is that the Supreme Court of Massachusetts is embarrassed by the Karen Reed case. And they're embarrassed by the detectives, and they're embarrassed by the argument. So the best argument for Karen Reed is the realpolitik argument. They're embarrassed and they're looking for an out. Okay, that could happen. $20 from Maximum Bacon. Thank you for this very generous super chat. That's very nice of you. Why do you think they chose not to attack the evidence and rules of evidence? Some of the arguments against some evidence that were allowed anyway seems like an easy win, so why not? That's a good question. I don't know the answer to that question. The most likely answer to that answer is page limits. Already, this is a very long brief. It's 60 pages, man. 70 pages. It's a long brief. So, the best argument I can think of is page limits, although I think you could have wrote what you wrote in less words. So if the problem was I need pages, I'm pretty sure I can consolidate this down. But I don't know. I don't know why they didn't make this is bullshit. I don't know why they didn't make that argument. I'd be interested in their reasoning. Maybe I could call them and ask. I mean, why didn't you make there is no evidence, this is absolute bullshit, no reasonable juror could possibly believe this bullshit argument? I know that's argument's basically borderline impossible. You know the argument's basically borderline impossible, but on this situation, I'm just saying, man, I think the impossible might come true. So I don't know. I don't know why they didn't make that decision. Thank you very much for your super chat. The only other reason I can think of is that they disagree with me on the balance of probabilities. Like, the only other reason I can think of not to make the argument is that they are purposely foregoing the argument. Well, there's a couple reasons. They're purposely foregoing the argument because they want to make the Supreme Court focus on this argument. They're foregoing the argument because they don't want to dilute their time, especially on oral argument, right? Because the Supreme Court of the state could choose like which arguments it wants to hear. And so they don't want to be forced in a position of arguing or splitting their time among multiple arguments. The other reason is that they think it's so weak. They think it's so weak that it would like hurt their overall presentation, because you don't want to make bullshit arguments because making bullshit arguments has a tendency of dragging everything else down. So it could be because they don't want to make bullshit arguments. I don't think they are in fact bullshit, but it could be like a strategic consideration. Otherwise, I don't know. His name is Mud. Are we quoting Primus now? Got to get this body in the ground before it starts to smell. My name is Mud. Are we doing Primus? What? Brendan, the new prosecutor? Yeah. Does the fact the case ended in a mistrial limit their ability to appeal the denial of the directed verdict? I don't think so. I don't think so. I don't think it would, because like that would be legal error, right? And the case has come to a conclusion. I don't think so. I think you can I think you can appeal the lack of the directed verdict. The case has been finalized in so much as we're trying to like, I don't see any reason why. I don't think so. I mean, we're already appealing anyway, right? We're appealing on the double jeopardy grounds. So our argument is the case came to an end. So since we think the case came to an end, then I think we could throw in the argument that, yeah, I think we can. I mean, I don't see any reason not to try. At least based on my understanding, I don't see a reason to try. Why bring in a special prosecutor? I don't know. Who can say why they think the way they think? Who knows? Who can say why they bring in different people? Who knows? Well, something tells me the feds know. Fair. Fair. Well, Lolly can't bring in a few witnesses, so maybe the new guy can do something different. I don't know. Well, thank you for the 500 of you who are here, by the way. I really appreciate it. I hope you guys are enjoying the new content I'm pushing out. The videos I'm doing seem to be well received, generally speaking. And some of these lives are doing reasonably well. Plus, we're trying to push more stuff on our other social media, like Twitter and Instagram and TikTok and stuff. So trying to keep engagement going there. So good stuff. There's a new Zelda game tomorrow. What's coming out tomorrow? Is it that kind of like 2D sort of style, or like cartoony one that I saw? Is that the one that like you're playing a Zelda that I saw like ad for? Because that kind of looked cool. The one where you play the one to play Zelda looked cool. I've been playing this game Shapes 2. It's been interesting. Yeah. Yeah, the new Zelda looked kind of interesting. I might play that. I might play some of that. That looks good. I've been playing the game, the fan created game, Dungeons of Infinity, the rogue game, the roguelike. Well, it's more of a rogue, but still, I've been playing that game a little bit. It's been kicking my ass. You gotta go to the ER? Oh dear, better go. All right, I think I'll send you on your way. Let's see who else is streaming. I'll send you on your way. Who else is streaming? Let's take a look. Take a look. No one is streaming? How can no one be streaming? Recovery Addicts is streaming. I'll send you a Recovery Addicts way. I'll send you over to Recovery Addict. All right. I hope you have a great day. Until later, my friends, I hope all is well for now, my friends. Cheers and goodbye.